as we are recording the session. So with that, I will pass it over to Kathleen.
Thank you so much, Selena. Wonderful to be here. I'm excited to see the range of people that are coming. I imagine we'll have some more join us as we go. And of course, a big welcome to those of you who are watching this on the recording after the fact. My name is Kathleen Mannion. I am based at Royal Roads University, and I'm very excited about this, this webinar and the discussion we're about to have. This is part of the lead up to the UN North American consultation on a child's right to a healthy environment. And we had thought that it would be great to have a series of webinars. This is the first one we're launching into in consultation with the Children's Environmental Rights Initiative, the International Institute for Child Rights and Development. The consultation is also in collaboration with the David Suzuki Foundation, but importantly, the work of our Children's Trust, who's really put this particular panel together, and we're excited about that. As we move into talking about concepts of children's rights, healthy environments, and the courts, it's really important for us to consider where we are in the world and to think about who's come before us in our particular locations and the relationships that the people that have come before us have had with the land, the air, and the sea. And with that, it is important that I acknowledge the traditional territories in which Royal Roads University is situated. It is situated and rests upon the lands of the Kosapsan and the Algonquin people, who have been in the Victoria region for far longer than Royal Roads University. And we acknowledge the important relationship that they have had to the land here within Canada. And I also invite you to consider where you are in the world and the relationships that the people who've come before you have had in your particular regions of the world. And with that, I really want to hope we have a fantastic conversation, and I pass this over to Paul, who is going to say a few words as well. Thank you, everyone.
Thank you, Kathleen. Hello and welcome, everyone. My name is Paul Rink, and I am a climate law fellow at our Children's Trust. I was in charge of planning this panel, and before we get started, I just really quickly wanted to first thank Selena and Kathleen at Royal Roads University for all of their technical assistance with today's panel. And in addition, I'd like to thank all of our participants. We have Delaney Reynolds, who's going to be our moderator, and Nathan Baring, Chris Tolfson, Catherine Smith, and Fernando Ochoa, who are going to be our panelists. In addition, I'd also like to thank all of you who are coming and attending today. We really appreciate you taking the time out of your morning or your afternoon or evening, wherever you happen to be today. So with that, I'll pass it off to Delaney, and I hope everyone gets a lot out of this panel. Thank you.
Thank you so much, Paul, and thank you to Selena and Kathleen for having me and for hosting us. Thank you to our esteemed panelists for being here. And of course, thank you to all of you for joining us from wherever you may be on your Friday to discuss what I believe is the biggest challenge that my generation, the youth generations, will ever face, our existential climate change crisis, and to talk about what a few of us are doing to try and implement some solutions. So as you heard, my name is Delaney, and I was born in Miami, Florida. I'm actually the fourth generation of my family to live in South Florida. So we have a very long history here, and I love the state of Florida and its incredibly diverse nature, including the vibrancy and natural beauty of Miami and Miami Beach, the serenity of places like Matheson Hammock Park, and all of its natural wonders, such as the Florida Keys, our state's amazing coral reefs, and of course, the Everglades National Park, the only habitat of its kind on Earth. Florida is where I grew up, where I learned to swim, fostered my love for nature, and now study marine science at the collegiate level. But I am deeply worried about Florida's future. The man-made carbon dioxide that is being pumped into our atmosphere and waters from petroleum products made from fossil fuels place much of our state and the rest of our country and planet at the very real risk of disappearing. of becoming extinct, being lost forever. And those concerns, along with our state, Florida's disregard for what is already happening, the immense flooding that we're already experiencing in every South Florida city, are just some examples of why I am suing the governor and the state of Florida. They have failed to honor their duties that are outlined in our Florida Constitution and the public trust doctrine, and the time has come for that to change. As such, 7 of my friends and I sued Governor DeSantis, Commissioner of Agriculture Nikki Fried, and essentially the rest of their cabinet in April of 2018 for not upholding their duties that are outlined in the Florida Constitution and the Public Trust Doctrine by pumping massive amounts of carbon dioxide into our environment, polluting our public trust resources, our land, our water, our atmosphere. They are not protecting our environment and our constitutional rights to life, liberty, and property. So for this lawsuit, we work with Our Children's Trust, a nonprofit organization that is led by lawyers, all working pro bono for free, because they too believe that this crisis is a major threat to today's youth and to future youth, future generations. And they understand that we need to implement solutions, serious solutions addressing the core cause of our climate change crisis, fossil fuel emissions, before it's too late. Our Children's Trust has multiple cases all over the United States as well as globally. So today we are fortunate to be hearing from a plaintiff of the Juliana versus the United States federal climate change case, as well as some lawyers from multiple different cases about their perspectives on these landmark lawsuits. So without further ado, to kick us off, we'll start with Nathan Baring. Nathan is focused on the nexus of climate and labor justice. His advocacy as a plaintiff on the cross-action lawsuit, Juliana versus the United States, has taken him all around the United States, speaking to diverse audiences, from high schoolers to community gatherings to the United States Senate. Yet, as a third-generation Alaskan, Nathan is also concerned about the state's oil-based labor force, which forms the current basis of their private economy. So his internships for Alaskan politicians at both the state and national level have clarified his commitment to bridging these economic and environmental divides. Nathan is currently studying political science and biology at Gustavus Adolphus College, and he intends to pursue a JD Master's in rural development, which will prepare him for a career supporting an equitable energy transition in the Arctic. All right, Nathan, kick us off.
Thanks so much, Delaney. Hi, everyone. Thanks so much for being here. It is my honor to speak to you today. As Delaney mentioned, my name is Nathan Baring. I am 21 years old. I'm currently a junior at Gustavus in St. Peter, Minnesota. And I'm also a third-generation Alaskan. My grandparents moved up to Alaska before statehood in 1957. And I'm also a youth plaintiff on the Juliana v. United States class action lawsuit against the federal government. And today I'm going to be speaking to you about how we use climate science in its objectivity as a vital tool to protect the constitutional rights of young people. Next slide, please. To start off, I want to make an important distinction between a political and a scientific standard when we're looking at climate science and we're looking at protecting young people. So when we think about climate science, often and climate negotiations, often what is evoked is the idea of international negotiations. So for example, most recently we'd think of the Paris Agreement and the 2°C target that it looked at for limiting global average surface temperature rise. And other negotiations have focused on a 1.5°C rise. What's really important to note about these two targets, though, is that neither of these targets have ever been considered safe from either a political or a scientific point of view. They've been a product of negotiations. And in fact, a 2018 IPCC special report on the 1.5°C target, the lower of the two political targets, made clear that it is not actually considered safe for most nations. And we might think of nations in places like Oceania or low-lying coastal areas, Florida, for example. And this is as compared to current warming that we are already experiencing. And so what's key here is that political negotiations have often been conflated with scientific protection. So this idea that if we can politically negotiate the target of 2 degrees as the limit or 1.5 degrees as the limit, then that's actually adequate protection. But what we see on the right from the World Resources Institute is that actually at both of these targets, we're still expecting, the scientists would still tell us that this is what we can expect on these four metrics of climate science as an example. And I would particularly call our attention to the bottom on coral reefs, which protect the majority of the ocean's biodiversity. So for example, at the 1.5 degree target, we would see a huge collapse in coral reefs or a 2 degree near perfect collapse in coral reefs. And so it is not really a fair statement to say that the political negotiations are actually are providing adequate protection. Next slide, please. So with the distinction being made, we need to ask, what does the best available science actually say in terms of where we need to go to be safe on climate? Next slide. For starters, I want to take us through a brief paradigm shift. So previously, the temperature targets we're talking about, as I mentioned, focus on global average surface temperature and kind of limiting the amount of warming we see as on global average surface temperature. But it's important to distinguish this from what we've also heard of, which is the carbon dioxide parts per million idea. And what that really refers to is basically the buildup of gases in our atmosphere, carbon dioxide being one of the key contributors to the greenhouse effect. So at any given time, there's a certain amount of energy that is coming in from the sun. And in order for the Earth to be in a sort of dynamic equilibrium, that same amount of energy needs to be leaving after going through a various litany of ecological processes. And what humans are doing specifically, and we may all be familiar with this, but what humans are doing is they are dumping excess carbon dioxide into the atmosphere as one component of this energy balance kind of dynamic. And what this is doing is it's trapping excess heat from the sun and not allowing it to go back into space. And so when we focus only on global average temperature, what we're missing is this broader picture that considers the kind of buildup and the imbalance that is constant, that is kind of expounding on itself, so that we're over time gradually increasing the amount of energy and heat that is trapped, and further locking in this destabilization. And it's important to note that focusing only on global average surface temperature misses important other parts of the system. For example, the reality that the ocean has absorbed the majority of the heat and energy that humans have pumped into the atmosphere, and processes like deforestation, which remove the Earth's natural ability to sequester excess carbon. Next slide, please. And when we also consider this paradigm shift, we note that there are serious consequences already in us accepting the political standards of 1.5 or 2 degrees Celsius as safe. And that's because at the current level of present warming at 1.1 degrees Celsius and at 412 parts per million, this kind of 62 parts per million above the 350 parts per million standard that scientists tell us is the safe metric to keep below. We already see a variety of weather and climate related disasters, and we see adverse impacts at the current level of warming far before we even get to these political standards that we are told are safe. So for example, noted on the left, in the Western United States, our wildfire season is now almost 3 months longer than the 80s. We're seeing an increase in 1 in 1,000 year rainfall events. We are seeing an exorbitant amount of money in the United States, as just one example, being spent in increasing amounts on weather and climate related disasters that are only expected to grow in frequency as the Earth's climate becomes further destabilized. And one effect that is important to me as a resident of the Arctic is declining snowpack and rising temperatures, and how that increases the length and the severity of drought. Most recently, we saw in 2020 in California what happens when there are incredible drought periods. Next slide, please. So with this being said, why is it important, especially for young people, when we're looking at protecting and using kind of this objective scientific metrics rather than political metrics on how we protect the constitutional rights of young people? Next slide. Well, for starters, we have to consider the specific implications of climate change and climate destabilization for young people. For starters, we have to take a step back and note that young people don't have access to political power, right? So young people do not have access to the political branches. They are pre the ability to vote, and so they have a much harder time affecting policy that is being used to promote an energy system that is causing this climate crisis. And I'll also note in the quote on the left, the longer the length of time that these concentrations remain above a dangerous level of atmospheric carbon, so above the 350 parts per million level, we risk what scientists refer to as kind of like a tipping point, or a point in which we risk locking in dangerous positive feedback loops, which is basically this idea that we have a cascade or a domino effect of various climate considerations that kind of build on what humans already kickstarted, but then it reaches a point where the natural processes sort of take over and humans actually lose the ability to recover the climate system because of the kind of runaway greenhouse effect. So as a particular example that's dear to my heart as an Arctic resident, I most often think of the permafrost melt. So right now there is an exorbitant amount of carbon dioxide and especially in methane, which is a much more potent greenhouse gas that is stored underground. And as humans have slightly tipped Earth's energy imbalance so that the permafrost melts, all of a sudden, not only has the permafrost melted, but it releases an exorbitant amount of these excess gases back into the atmosphere all at once, which further compounds the problem and is one example of these positive feedback loops that can eventually reach the point where humans have lost control of the ability to reverse climate. And what's important there is that if children do not have access to political power, we risk reaching a situation when children come into the political branches, full of idealism to reverse the trend on climate change and ready to correct our trajectory, but they've already run out of the point in which that's possible. So children reach the political branches at a time when it is no longer possible to correct climate change and to kind of rein in the effects based on this idea of a tipping point and positive feedback loops kind of taking over. Children at a more micro level are also uniquely vulnerable to climate change health impacts, as many experts have noted. For example, we think of the respiratory systems that children have in their developing stage and how wildfires, increasing wildfires from climate change might affect their developing lungs as one example. Climate change also causes adverse mental health impacts. So, the most visceral example would be if you can imagine being a child and almost seeing climate change like this oncoming train that you're powerless to stop and that no one else seems to be willing to stop for you when they have the power to stop it. And the kind of existentialism and the severe anxiety and kind of almost depression that can be caused by that amongst many other mental health impacts. And finally, I'll note just as a micro example, this is the city of Miami right here. And I chose this specifically because I have one of the plaintiffs on Juliana v. United States with me is a young male named Levi, who is also facing the same kinds of sea level rise effects in Florida as he gets older. And this is the modest predictions. This is on our current trajectory, NOAA's modest estimate, which says that we might experience 5 to 8 feet of sea level rise. This is by 2100. And so if we aren't taking corrective measures, these are the effects that will be visited on young people without their ability to correct them. Next slide, please. So why does this connect to constitutional rights? Well, lucky for us, constitutional rights are not political in that the court does not have to consider politics in the same way as international negotiators do. And so if science is apolitical and constitutional rights are apolitical in nature, then they work very well in tandem. So if we can establish, as courts have already established in the Juliana case, that it's clear warming is already adversely impacting young people with particularized injuries, and that the government, which has a public trust and Fifth Amendment duty to protect a livable climate for young people, is abandoning that duty and actively contributing to the climate crisis against 50 plus years of expert scientific data that tells them that that is the wrong move, that they are endangering the futures of young people. That is when the court can step in and say, here is the constitutional rights violation, and here is the objective scientific metric that shows us where we actually have to be to correct this constitutional harm. So to sum that up, if the best available science provides the metrics for constitutional violations and they aren't having to consider the winds of political expediency, what interest groups think is possible, or what protects profit, or considerations like that that have to factor into negotiations like the Paris Agreement. And especially in court, it's to be quite simple. The data doesn't lie, and the government cannot contest data in the sense that lying in a court is perjury. Next slide, please. So in conclusion, constitutional violations in this area must be based on the best available science. And so all government policies regarding CO2 emissions should be aimed at reducing global carbon dioxide concentrations below 350 parts per million by 2100, the scientific metric that is objective, not subjected to political pressures. And in the future, we should also always be focused on limiting warming to scientific parameters rather than political targets. Thank you so much for listening.
Thank you so much, Nathan. I always love hearing from other passionate plaintiffs, especially because we can provide the youth perspective. And now that we understand the science a little bit better, let's now hear from Catherine Smith. Catherine joined the faculty at the University of Denver Sturm College of Law in 2004, and she teaches torts, children and the law, and sexuality, gender, and the law. She has published in legal journals, including Wisconsin Law Review, Washington University Law Review, and UC Davis Law Review. Catherine's research seeks to develop and expand children's equal protection rights. Her co-authored amicus brief on children's rights was cited and relied upon in the same-sex marriage decision, Obergefell versus Hodges, and Catherine is currently serving as an expert in the Juliana versus United States landmark climate case, brought by our federal plaintiffs, such as Nathan. So go ahead, Catherine.
Thank you, and thanks to everyone for being here today. Nathan, excellent presentation. Thank you for providing the science. I am going to talk about, my talk's really going to be US focused. I look forward to learning from other, my co-panelists and others about the global fight for children's rights. I'm going to focus on how we address the harms to young people that Nathan highlighted in his talk, especially those who are members of already vulnerable groups. Children of color, children in indigenous communities, children who are members of low-income communities, children at sea level. I read a stat recently that 99% of the children who die from climate change at this point are those who live in underserved communities. And I'm really gonna think about this and offer a bird's eye view of children's rights in the United States. To tackle what we know of as an explicit, but also implicit mindset that perpetually prioritizes adults' rights and adults' interests. This is particularly true in the United States and in constitutional law. And I've been lately just sort of describing it as our constitutional law as embodying an adults' rights-bearing prototype. And I'm going to focus mostly on the 14th Amendment Equal Protection Guarantee, though I think this observation cuts across US constitutional law in general. So in Obergefell versus Hodges, the landmark decision recognizing same-sex marriage, really recognizing same-sex couples' fundamental right to marry, the United States Supreme Court explains that in interpreting the Due Process and Equal Protection Clause, quote, new insights and societal understandings can reveal unjustified inequality within our most fundamental institutions that once passed unnoticed and unchallenged, end quote. In that vein, Obergefell, the majority, relied on its modern understanding of the harms of sexual orientation discrimination to strike down same-sex marriage bans as unconstitutional. And as I've said before, this iterative process, developing new insights and advanced understanding of harms, of group-based harms, should be incorporated, and then incorporating those lessons into the fabric of constitutional law should apply to children, and especially children in the context of this crisis, in the context of the science that Nathan just provided, and in the context of the present and future harms to children caused by government conduct. So when it comes to children, the 14th Amendment's promise to abolish laws that suggest a kind of class or caste treatment has yet to be fulfilled because our founding documents prioritize adults. They always have. There's no explicit reference to young people in the Constitution, the Bill of Rights, or the 14th Amendment. And although, and I'd say as children have historically, and I'm going to talk about this a little bit, they've historically been objects and not subjects of the law, as scholar professor Barbara Woodhouse has explained. Children have functioned more in the role of parental property than as persons. So over the last 60 years, we've seen that children have been judicially recognized as rights bearers, yet the 14th Amendment's adult rights bearing prototype is so ingrained in our popular imagination and legal doctrine that children's rights continue to be limited in scope, substance, and theory. The most prevalent reason for limiting young people's rights is that they lack the capacity for autonomous choice. This lack of autonomy dictates that instead of recognizing a full range of children's rights, society should rely on parents to act in their children's best interests. This parent as proxy reasoning is so prevalent across the political, and it's across the political spectrum, in all sorts of groups. This idea that even when parents' rights are not in tension, because of this idea that parents should be acting in the best interest of their children, even when parents' rights are not in conflict with children's rights, it sort of invokes this knee-jerk reaction when children's rights come up. There's also, and I'm going to talk about this more, this sort of unacknowledged implicit shift to an adult focus. And it's sort of like an adult default. Whether explicit or implicit, that adult default stands in the way of a robust engagement of whether, why, how, and when children's rights matter. A perfect example of the unacknowledged shift to an adult default happened in Juliana. In the panel decision in the Ninth Circuit, the court acknowledges the pending environmental apocalypse, yet tells young plaintiffs that they must go to the ballot box, even though most of them cannot vote, because in the United States, one must be 18 to do so. So even in the court's mind, even though it's talking about kids who are kids plaintiffs, there's this implicit shift to this adult default, adult standard, or adult sort of facts, instead of looking at the unique circumstances of kids or children or young people. And so this sort of notion that parents must act in the best, that parents act in the best interest of their kids, and so we don't need every more robust children's rights theory or doctrine. There's an implicit assumption there also, and that's that parents have the requisite political power to act on behalf of their children, right? So just think about that it said, well, we expect parents to not, as Nathan said, children might not have that requisite political power. Well, that's actually true for a lot of children's parents also, and in particular, the children who are marginalized or who are getting the greatest brunt at this point of the climate crisis. But what's interesting is sometimes, even though those politically powerless parents might not have the power, children as rights bearers achieve what their politically powerless parents can't. Brown versus Board of Education offers an apt example. So after more than 50 years of an oppressive Jim Crow regime, Black children delivered the final blow to the separate but equal doctrine. We think of Brown versus Board of Education as a civil rights icon, and it is, but it's also a children's rights case. And Brown what it provided was a critical constitutional check on the government's exertion of control over young people in order to maintain a racial caste system. The court stepped in to stop racial segregation, but it also stepped in to halt the existing and future injuries to Black children and Black communities. So this leads to a second reason for which I think that there's an incomplete and incoherent state of children's rights. Cases like Brown versus Board of Education are overlooked. Lawyers, including jurists, fail to see Brown as part of a children's constitutional law canon. So even when children's rights are acknowledged, right, we know that the plaintiffs in Brown were kids or children, but even when they're acknowledged, ultimately that subsequent precedent that comes from it often drops the precedential meaning of the case that has a kid's element to it. Our challenge, I think, for children's rights is to overcome this adult default mindset, factually and doctrinally. When we do so, we can observe some really interesting equal protection law precedent, or even 14th Amendment precedent, that might offer us a path forward for children in many areas, including our government's failure to reduce emissions. So more than a decade after Brown, in Levy versus Louisiana, the Supreme Court invoked Brown's principles to intervene on behalf of children who were socially and legally ostracized because their parents were not married. The court refused to allow government practices that denied children basic rights and securities. A decade after Levy, in Plyler v. Doe, the court stopped Texas school districts from depriving young Mexican immigrant children an education because their parents were undocumented. In Plyler, the court, citing Brown, described education as providing, quote, the basic tools by which individuals might lead economically productive lives to benefit us all, end quote, and raised the alarm about its deprivation as exacting an inestimable toll on the social, economic, intellectual, and psychological well-being of the individual. In Obergefell versus Hodges, the Supreme Court fell short of recognizing children's rights. However, it did heavily rely on the harms to children in the present and into the future, whose parents were denied the fundamental right to marry. In these children's rights cases, it's no coincidence that the children face these injuries because of their youth and their membership or connection to certain groups: African Americans, unmarried parents, which was correlated to race, undocumented Mexican immigrants, and LGBT people. It's not to say that these cases are not civil rights cases or family law cases or immigration cases or LGBT cases. It's to say that they're also children's rights cases that are offering a burgeoning children's rights jurisprudence. And at base, they tell us that there are times that legal actors must step in to protect children, especially children in vulnerable populations, from present day, and to protect them from present day and future harms caused by government action. From a children's perspective, as a theoretical and doctrinal matter, these cases mandate an aggressive children's rights framework that affords a critical constitutional check on the government's imposition of egregious harms to young people. We must continue to push to place children's rights, interests, and futures at the center of the climate crisis and constitutional law. So I look forward to your comments, and thank you.
Thank you so much, Catherine. Your work is truly fascinating and inspiring, and as a child myself, I can definitely confirm that it's certainly helpful to have adults, especially our lawyers, supporting our actions. And speaking of, we will now hear from Chris Tollefson. Chris is a professor of law at the University of Victoria in Canada, as well as the founding principal of Tollefson Law and the founding executive director of Pacific Centre for Environmental Law and Litigation, Canada's very first charity dedicated to educating and training aspiring public interest environmental litigators. His counsel work has included appearances before all levels of court, including the Supreme Court of Canada and at various environmental regulatory boards and tribunals. He was counsel to BC Nature and Nature Canada during both the Enbridge Northern Gateway and Kinder Morgan Trans Mountain Pipeline hearing processes. He is also co-counsel on Canada's only national youth-led climate case, La Rose versus the Queen. His publications cover a range of environmental and natural resource topics, including environmental assessment, eco-certification, and access to justice. He's also the co-author of leading environmental law and policy textbooks. Go ahead, Chris.
Thank you so much, Delaney. Thank you to the organizers. Thank you to Professor Smith and Nathan for setting up this panel, setting up this topic so well. Firstly, I'd like to gratefully acknowledge that I am joining you from unceded Coast Salish territory here on Vancouver Island. I'd also like to confess to you that happily I'm taking a break right now with you guys from factum writing on the LaRose case. We are actually filing an appeal factum on Wednesday. So that creates a couple of potential things that I need to be alive to. One is the danger of taking you too deep into the legal nerdy stuff that I'm dealing with in the writing of this factum, but also I have to be a little bit careful about oversharing confidential legal strategy stuff. So if I pause before answering some questions, that is more than likely why. Selena, next slide, please. So this picture depicts the day that we filed the lawsuit, and as you can see right near the center of the picture is Greta, and along with her are 15 young plaintiffs. This slide basically is an overview of the things I want to try to hit in my, I guess I have about 15 minutes here. I want to tell you a little bit about the lawsuit. I want to talk as well about the legal concept of justiciability and how it's relevant to our discussion today. In that same vein, I want to talk about how courts respond to legal arguments about science more generally. And then, in the remaining part of my presentation, I want to talk about how, in our case, we've tried to position the arguments in a way that will get traction, that do address judicial concerns about whether and in what circumstances litigants should be allowed to argue about science, in particular about climate science. Next slide. So here's a better picture of our 15, well, I think 14 in that picture. One of the plaintiffs couldn't make it. Wonderful young plaintiffs from across Canada, from coast to coast to coast, all of whom are politically active around the issue, all of whom have suffered impacts associated with climate change of the type that my other panelists have been talking about. Much like the Juliana case, we have framed our case both as a constitutional case about constitutional rights that belong to these plaintiffs and to all Canadians under our Charter of Rights and Freedoms. But we also say that this case raises important issues about the duties of the state, about the federal government, to protect important public trust resources, including the air and the atmosphere, the territorial seas, and as Nathan has pointed out as well, the permafrost, which we say in Canada is a very important ecological asset going forward. Our case immediately upon filing was faced with a motion to strike. Canada wanted to shut down the lawsuit and it went to federal court, and we argued about that last October. A decision from the court was rendered shortly after that, and the decision was to dismiss our case, and it is from that decision that now we are appealing to the Federal Court of Appeal and filing our factum on Wednesday. Next slide. I want to share with you, I think, a concept that we're grappling with and pretty much every climate litigation team has to grapple with, which is the justiciability issue. I think it's the biggest single issue at this point in the evolution of climate litigation. It's the biggest single barrier and issue to having courts deal with these issues. What is justiciability? Well, the courts have not done a very good job defining it. Often it's defined in a very circular way as a matter that's suitable for adjudication. Well, what does that mean? In Canada, at this point, we don't have a political questions doctrine like in the US, which stipulates that certain questions are just too political to be brought before and decided in court. So we don't have that particular barrier, nor do we have a rule that a case that's just too complex scientifically can't be brought to court. So we don't have any hard and fast rules about what kinds of cases can be brought forward. But we do, I think, at the same time, have a pretty strong judicial resistance to certain kinds of cases being brought forward. And so what the courts in Canada, and I think in other places, the US certainly, have insisted upon before a case can be heard is that the parties that have brought it must show that the case has a sufficient legal component, that there's a legal issue at the center of the case. And of course, constitutional rights usually can supply that legal component. But in addition to that, the courts also are insisting on something that they term a judicially discoverable and manageable standard. There has to be some kind of standard in play articulated by the plaintiffs that the courts can apply. And it's this judicially discoverable, manageable standard that I want to talk a little bit more about. Next slide. But before I get into that, I guess I want to frame this a bit more broadly. My experience as a public interest environmental litigator is certainly that courts don't like being brought into controversial environmental cases, partly because they feel that they belong better in the political arena, but partly because they may doubt that they have the competency to deal with these issues. And governments typically will play to this concern by telling courts that they should decline to hear a case because it would turn the courtroom into an academy of science. And so I think there's many cases where this argument is made, and I think it's important, and I think we've quite successfully pushed back on this on the footing that courts deal with complicated scientific issues all the time. Whether in medical malpractice cases, intellectual property cases, various other cases, courts do have the competency, and it is their job to deal with complex science if there is a legal question that science is relevant to. Next slide. So that brings me to the JDMS, Judicially Discoverable Manageable Standards. What progress are we making in terms of persuading courts that climate cases have this element, have this component? Well, I think recently, and this is a very recent case from our Supreme Court of Canada, I think recent cases suggest that courts are coming to appreciate that climate impacts are measurable, not just at a global scale, but that we can measure the impacts associated with the incremental impacts associated with GHG emissions from nations and maybe even from subnational units. Certainly, that's what the Supreme Court of Canada seems to be saying in this recent case that was decided just a month ago. Next slide. Bearing all of that in mind, and of course we filed this a couple years ago, bearing that in mind, we knew that this question of JDMS was going to be central. We also knew that it was important, as Nathan has underscored, that and others have underscored before him, that we want to tether our case to the absolutely best available science. We don't want to tether our case to politically brokered targets. And so, working with OCT, we made the decision to plead, to kind of lay out in our statement of claim that our case does rely on the best available science, which in our view at this point is that the 350 ppm metric, or 1 degree Celsius standard, that really does define the point of dangerousness, of the point of serious risk, and the standard that we should be looking at. Now, of course, setting that out in your pleadings is only part of it. Canada is still is not the largest GHG emitter in the world. But it's in the top 10. Certainly, courts are going to be worried and concerned that we can somehow define what Canada's contribution, what its fair share of that global problem is. So, part of our strategy, which I can share with you, is that we felt it was important to be able to articulate in the pleadings some way of translating from that global number to a metric that we can pin on our federal government. And to do that, what we've pleaded is that we say that number can be derived using a carbon budget methodology, a methodology that identifies what, if any, remaining CO2 emissions can be emitted globally without putting the planet at risk. And then from there, deriving, using a formula that nations can agree upon, what each nation's own contribution, what their fair share of that global budget should be. Now, I think carbon budgets are becoming more and more accepted. I think they are quite a revolutionary concept in terms of the rollout of science going forward. Here's where I don't want to share too much about our strategy, but I will leave you with this one last slide. We have used carbon budgets, and maybe we could just move to the last one here, Selena. We have used carbon budgets in the past in legal proceedings, and although they haven't gone to court, these are in regulatory proceedings, we have found that they're a powerful tool to underscore these very stark choices that confront us. And so when we're fighting against, and these are big infrastructure projects, both of which thankfully we were able to defeat, in both of those cases, we were able to use carbon budgets as a way of showing what the impact of approving that project would be going forward. Now you can see in the case of the PNW Northwest LNG, for example, that it was projected under our estimates that it could consume up to 11% of Canada's all-time carbon budget, which is a pretty remarkable thing. I think a statistic that very few folks, even well-informed folks, were aware of. But let me add an additional gloss to that. That 11% is based upon the Paris targets. That's based upon a 1.5 to 2 degree global average temperature change. So if we move from there to a 350 and 1 degree scenario, you can see that the carbon budget numbers are going to look even more stark and powerful. I think at that point, Delaney, I think I'm just going to stop because I'm sure that I'm close to my time, and I look forward to, thank you very much. I look forward to the discussion that follows.
Thank you so much, Chris. Thank you for diving a bit into the behind the scenes of the lawsuits and the importance of science backing our cases. So now we'll actually be hearing from another lawyer, Fernando Ochoa. Fernando is the founding member and executive director at Defensa Ambiental de Noroeste, a Mexican nonprofit organization whose mission is to protect the ecosystems, species, and environmental human rights in Northwest Mexico. Fernando is a public interest environmental lawyer with law degrees from the Universidad Intercontinental in Mexico City and a diploma in environmental law and policies from the Universidad de Estudios de Posgrado en Derecho, also in Mexico City. He has a diploma in criminal law by the Instituto Nacional de Ciencias Penales, also in Mexico City, and his work experience includes 4 years as an associate lawyer in a private attorney's office bureau, as well as 19 years of experience in environmental law and conservation in the nonprofit sector. Fernando is an active member of the Environmental Law Alliance Worldwide and a former legal advisor for the Waterkeeper Alliance programs of the Baja California Peninsula. His successes, along with a team of specialized lawyers, including halting the construction and operation of ill-advised development and industrial projects, protecting endangered species and fragile ecosystems in Northwest Mexico. Take it away, Fernando.
Sorry, there you go. Thank you. Thank you, Delaney, and thank you to my fellow panelists. It's just fascinating to hear from your perspectives in the matter. To the best of my abilities, I will try to explain our case in 10 minutes of time, and I'll start by giving you a little bit of context of so that you understand where this case comes from. I live in Baja California. It's a neighboring state to the south of the state of California in the US. Baja California is a big chunk of land, for the most part pristine. And it has the Pacific Ocean on one coast and the Gulf of California in the other coast. And I say this because I have witnessed firsthand the effects of climate change. I've been a passionate of nature for as long as I can remember. And I enjoy, I cannot put it into words how much I enjoy to spend my time in the wilderness, and it's just painful to watch how climate change has affected not only the environments, of course, and the ecosystems, but the species themselves. And on the other hand, I am the father of a 9-year-old, and it is so frustrating to acknowledge that my daughter, she won't be able to see what I saw 15 years ago because it just disappeared. Again, I say this word very responsibly. It's just painful to watch. So in late 2019, we partner with our Children's Trust to file the very first lawsuit of this kind in Mexico. We filed a constitutional lawsuit on climate change on behalf of 15 children and youngsters from Baja California. I'll try to talk or explain the 3 basic premises under which we constructed this lawsuit, this case. That will be, in the first place, the best interest for the child. Second, what we're exactly demanding objectively, and what do we foresee for the future? What do we want? And how do we think we can make a change? climate justice naturally implies intergeneration equality and the best interest of children. And so for this reason, our lawsuit is based on the principles recognized by the Mexican Constitution, which is our most important ruling law, the United Nations Convention on the Rights of Child, and the general law for children and youth rights in Mexico, among others. So for this reason, one of our basic requirements to the court is that as a priority principle, while studying our case and while making considerations for a judgment, the court applies at all times the best interest of the children. Interestingly, Mexico is a very good country to pass laws. Our laws are, on a general basis, pretty good laws. Problem in Mexico is the rule of law. So nobody reads the law, judges included, but I'll leave it at that. What's very interesting is that our general climate change law, in its Article 26, establishes that the Mexican state, when adopting measures to tackle climate change, it shall unrestrictedly respect children's rights and intergeneration equality. That's just fascinating. So, of course, we based our lawsuit on this principle. Also, we included arguments that the Mexican Supreme Court of Justice established that the decisions adopted or taken by authorities in the context of education, health, conditions of life like well-being, immigration, and environment must be evaluated and be guided by the principle of the best interest of the children. And last but not least, we also included in our lawsuit what the President Minister of the Supreme Court of Justice in Mexico said, in the fact that all the judges in the country must privilege and prioritize the fundamental principle of the best interest of the child because they're the future of the world. That is said by the President Minister of the Supreme Court of Justice in Mexico. Regardless of this, when we filed our lawsuit, first thing that the district court said was that the children and youngsters that had filed the lawsuit didn't have legal interest. I mean, unbelievable. Fortunately, after we appealed that decision, a tribunal collegiate court demanded the district court to accept the lawsuit. So as we speak, we are litigating the first climate case on behalf of youngsters and children in Mexico. What are we demanding? Unfortunately, in Mexico, climate change is less than a ghost. Nobody wants to talk about it. Nobody sees climate change. And that is in every context you want to put it. So we are way behind of where we should be if we acknowledge that Mexico is one of 10 countries responsible for 73% of the emissions put in the air every year of CO2. So we should be at the very front of the line tackling climate change, and we're at the very back. So we are demanding that Mexico has the basics to measure our performance on emissions and climate change. We don't have it. And if we don't have that, we cannot demand from the federal government or state governments or municipal governments to meet the 350 standards or the 1 degree Celsius, because we don't have the tools as a country to act on it. So that's what we're demanding. We're demanding the federal government to elaborate and publish all the instruments and policy to make Mexico, for the Mexican government to be able to tackle climate change. I won't mention all of them, but there are at least 15 policies that Mexico should have right now in order to tackle climate change. What do we want? So once that the Mexican government has the tools to properly evaluate Mexico's performance on emissions to the atmosphere and its performance on climate change, once we have that, we will demand that Mexico meets the CO2 levels below 350 as a fundamental premise to restore Earth's energy balance and to stabilize our climate system. And we will demand that all policies must be based on this 350 parts per million and 1 degree Celsius to protect young people and future generations. One last comment. I will insist that the best climate science today says that if we want to restore all the atmosphere, stabilize climate system, and protect the oceans from acidification and warming, it is required to return to atmospheric carbon dioxide concentration levels to below 350 and limit long-term warming to not more than 1 degree Celsius. That's very important to consider, because even though we are not at that stage in our lawsuit right now, as a precedent and as a fundamental principle, we are already saying it, even though we're not demanding it right now. So with that, I will leave you. I hope we can continue to learn from my colleagues at the panel, because their talks are just fascinating, and it's also fascinating to share the fight against climate change with such bright and intelligent and committed people. Thank you very much.
Thank you, Fernando. Thank you for that great summary of the Mexico climate case. So now I'm very excited. We've been collecting your questions in our Q&A function, and I'm going to go through them, ask our panelists your questions. If you still have questions, feel free to add them right in there, and we will get to them if we have time. So to start off, we have a question for Nathan from Olivia. And she wants to know that now that you're of voting age, just as she is now, do you feel that this actually makes a great difference on your sense of power? She feels kind of powerless when it comes to democratic institutions, even where in countries that are perceived as functioning democracies like Canada are skewed to favor people who are already in power and don't really give room for real change to take place. So what are your thoughts on that?
Yeah, awesome question. I'm absolutely sympathetic and totally agree with the sentiment that we have a very tipped power scale, even in the traditional legislative forms of democracy. But I think that what I'm really getting at in why I think that the voting distinction is so key, for me at least, is when earlier it was mentioned that the United States has the concept of the political question doctrine, and what's really key as a young person, before I was able to vote, because I started this case when I was 15, is this idea that it was okay to say that the government has acknowledged that it's actively contributing to the climate crisis, which is affecting young people in these ways, and that this is only going to get worse, and the courts acknowledge that. And despite this overwhelming evidence, young people who don't have the right to vote must make their case to the political branches. I think that it's really important that specifically for young people, there's kind of this distinction that should be made in, it's not really okay to say, go to the political branches under the political question doctrine in US law when we don't have the political branches as young people. So I think that I absolutely agree with the sentiment that we have a really skewed power balance, and we would need to look at that as well. But I just would say that this is, for the purposes of this lawsuit, the political question doctrine is a barrier that should be looked at differently for children. And that's kind of how I'm looking at it.
Awesome. Thanks, Nathan. This next question is from Dr. Mark Hayden, and he's asking, could it be argued that pediatricians have a duty of care for their patients, and if they do not address air quality and other environmental risks by education of their patients and parents and other actions, that they are in breach of their duty of care? So I think this question is kind of geared towards Catherine. So if you want to start off, and then if anyone else has any thoughts, they can share after.
Oh boy. I mean, technically, as a torts professor, I'm guessing the US context, I think it'd be difficult to just, I don't know, I think it'd be tough. I'd have to hear more about how that duty would be created. The definition of duty in basic negligence law is the legal obligation to conform one's conduct to a particular standard of care. So we'd have to figure out, where would that duty come from? I mean, it'd have to be either statutory or, and so I think that would be one of the challenges, at least in that context. Maybe there's some other context that the person asking the question is thinking about, and I'd love to hear about that. But I think just in the abstract, that's what would have to happen, is you'd have to figure out where would that source of the duty come from legally. So thanks. I'd love to hear if anybody else has any thoughts about it.
Okay, cool. If anyone else has any other thoughts, or Dr. Hayden, if you want to expand on that or chat with Catherine, feel free to send us another question, or even just put it in the chat and we can all see it. Okay, so the next question is from Wendy Kerner, and she is asking, is there any validity in an argument that Canada or the United States climate change policies influence whether other countries implement stringent enough policies, and therefore that could affect global emissions? So I think I'll let Chris start with this one.
Well, I do think that the question is closely related to a key problem that litigators and courts are grappling with, which is, what responsibility should we impose on countries where there's a good chance that other countries will not act and therefore defeat or nullify the benefit of the actions taken by countries that do step up. I think it's a collective action problem. We can't parse it out and say that because what we do may not ultimately make a difference due to what other countries fail to do, that's a reason that we shouldn't be obliged morally and legally to act. And I think actually the passage that I pointed out in my slide deck from the Supreme Court of Canada is right on point. It basically says, well, there are measurable harms that each jurisdiction should be responsible for, and if we go down the road of exonerating countries from liability because it may not make a difference, then we're lost. It's hopeless. So it's a good question. It's the central question, really, and I think we've made some progress on that.
Thank you, Chris. So this next question, I would really like all of our panelists to address. I think it's an important one, and it's one that I've received often. So the question is, some groups will assume that children and youth are being used and influenced by adult-led groups, agencies, and organizations to fulfill their own agendas. How do you counter these arguments? So I would like to start with Nathan, who is also a plaintiff, so he can address that on his own.
Well, yeah, I was going to say that I love this question, but actually I guess that's that might be an improper framing, but it's an important question is what I'll say. Well, as I mentioned, I joined, this case has now gone on for more than a quarter of my life. So when I started it, I was 15. And so especially when I was 15, this question came up a lot. And I even remember being specifically in the state capitol in Juneau in Alaska and coming across a legislator in the hallway who really did say, and it was interesting, almost in a sympathetic way. Oh, it's really nice that you can parody the opinions of your parents. But the funny thing is that was the kinder version, because that legislator was sympathetic, but you see it on kind of both sides. You see either, oh, good for you, you're so powerful, I'm glad your parents put you up to this, or like, oh, your parents put you up to this. And so, but what I would say to that is, kind of from the snarky response, I would hope someone could look at my like 10 years of independent activism that my parents can't even keep track of to know that like it has nothing to do with my parents. That's like my snarky answer. But my more intellectual answer is, you know, does it make a difference, basically? Like not does it make a difference in terms of, oh, it's important that children are forming their own independent opinions, but more, if I look, for example, at my 3-generation history in the Arctic, if my parents tell me about like how life was different growing up and how they can remember, you know, experiences with, you know, Arctic climate and all these things that I'm not going to be able to experience in my lifetime because the climate has changed, then I'm more importantly not even going to be able to have an inkling of showing my grandchildren that. Is it a bad thing that my parents influenced my opinion in that way by telling me of the history of where I'm from, or telling me that there's danger coming down the road that they can't stop for me? And so I would also argue that, like, you know, in a sense, children are influenced by their parents because we're growing up, but that doesn't have to be a barrier to also having our own sense of why we're fighting for what we are losing and what we still believe in.
Perfectly said. I'd like to pose the same question to Fernando. Have any of the children in the Mexico lawsuit faced such questions, and how do you address that?
Yeah, thank you, Delaney. Yes, the answer is yes. We've had these questions made, especially by the media when we came out and announced about the lawsuit. I would say 90% of the media came right after the youths and the children with that question, and our answer has to do with what Catherine said. Children rights and youth rights are most of the time neglected under the assumption of their capacity, like if they were not capable of thinking on their own and having wishes and having expectations for the future. Like it's just incredible that there's this prejudice. And the other thing is that because of this prejudice and neglected way of thinking, the spaces for children and youths to participate in decision-making processes are very narrow, if at all they are, or they exist. We're only providing opportunities for them to act on what will be their planet and act on their own and on their behalf and in their own capacities. So it is a very interesting discussion that shouldn't even take place. But I couldn't agree more with what Nathan said. And I think that what Professor Smith said in the presentation is pretty much the answer to every question people do on this regard.
Thank you, Fernando. So I want to move on for the sake of time to the next question so we can get as many in as possible. So for Catherine, do international policies about children's rights have any influence on judicial decisions in the United States?
So I'm not, it's not my area of expertise really in terms of the international and comparative law, and I'm learning that. I'm really interested in it. I was actually having a conversation with an expert on the Convention on the Rights of the Child yesterday, and what's interesting is linked back to this really in the US really strong parents' rights agenda, which tends to block that the ratification. And the other thing I'd say is that, I believe in a multifaceted approach, first of all. So I think, yes, that would be great if that could happen and help us push this. And I think even in an educational context outside the courts, it'd be helpful for us in the US. But with the Constitution or the composition of the court right now, I think there's probably going to be a lot of the Supreme Court and the courts in general. There can be a resistance to international and comparative law, and I know that would be shocking to many people, but there can be a certain resistance to turning to international or comparative law or what other countries are doing, and so we still really have to stay uber focused on our constitutional law and thinking about how we reframe our mindset around children's rights and move away from that sort of adult default way of thinking. I also just want to flag really quickly back to the previous question about using children. And I think one of the big points in my talk and what I think about is that children are being used by the government in a lot of contexts. And so the question really, and I'll explain that, but the question really is assuming neutrality or objectivity. And we're not living in a neutral or objective society. In Brown versus the Board of Education, I mean, if I put it into a personal context, my parents grew up, they were born in the 1930s, and they were educated by pew in a church because they were Black. They weren't allowed to go to school with white children. They weren't even given an education. They were taught by their relatives. And that I'm saying, and Brown's holding said, hey, yes, it said segregation is wrong, but my interpretation of it, and I haven't seen this very often or at all, is that it also is saying the government can't use children or place children, whether explicitly or not, in a position in which they are relegated to a caste or second-class citizenship, and have harms inflicted and imposed on them based off the government's actions. And to say, well, to bring a claim on behalf of a kid because you're going to use a kid to try and challenge that, to me, is just makes no sense. It's like, well, we got to do something because the parents don't have the power to, Black parents didn't have the power to do anything about it politically because of that rampant, discrimination against them. And thank goodness kids' rights popped up in that context. There was some lens from the court that they could actually see these harms, even though they couldn't see it when it was adults, right? And that's the window. Those are the windows where we have to think about, okay, well, what are those cases saying when they crop up? And let's stop ignoring them. So anyway, sorry, it's a long way to just say, we're not in a neutral place and we have to be super aggressive about representing kids. So I'll leave it at that.
Thank you, Catherine. This next question is for all of our lawyers. So if we were to look at experience worldwide, what is the evidence that suits by youth plaintiffs in regard to climate change are likely to eventually succeed? Are we wrestling with a not very practical approach? So I'd like to start with Chris.
Well, my view is that the battle that we're waging is existential, and it has to be waged on a variety of fronts. So it would be a huge mistake to pour all our resources and hopes into lawsuits. But I don't think anybody is suggesting that's what we do. I think lawsuits have a role. They have a role not only in terms of moving the dial with respect to potentially actually winning some of these cases, actually forcing through court orders governments to do more, which is obviously what all of us as litigators are there to achieve. But I think that there's spotlighting and educative and a variety of other important sort of ally building functions associated with these lawsuits. But yeah, the lawyers in those cases need to also help out in other areas. They have to do sessions like this. They have to recognize that they're part of a larger movement, and we have to be strategic and talk to each other. And yeah, so that's what it's about. It's going to be tough. Not every case is going to win, but that doesn't mean that they weren't worth bringing.
Absolutely. Nathan actually wants to answer this question as well, so please go ahead.
Yeah, no, I think it's a very fair question. And what I really wanted to emphasize is that like the Juliana v. United States lawsuit didn't spring out of nowhere. We stand on the shoulders of decades and decades of groundwork that was laid on the streets and in other forums. And I would also like to note that Judge Ann Aiken became the first judge in United States history to say that there was no doubt in her mind that a climate system capable of sustaining human life is fundamental to a free and ordered society. That was a really important tipping point, I would argue, in the history of the courts on this issue. And then to kind of look at it more, look at other comparative issues more broadly, like I don't think I know many lawyers that would argue that the Obergefell decision came out of nowhere either. For example, it was also the result of decades of groundwork that was laid all the way dating back to, the riots in San Francisco and the movements on the ground and the resistance that laid the foundation for the court to eventually catch up with the times. So I think that we're in a pivotal moment where that groundwork's been laid. And so I think in addition to still remaining vigilant in our organizing, we've also reached a point in which it's time to let lawsuits hold the court to the standard of our time as well.
I totally agree. And Fernando, in just a couple of minutes, are there any precedents for the Mexico lawsuit?
No. As I said, this is the very first time that a lawsuit of this kind has been filed. However, I must say that this is to file a lawsuit. The way we see it is the way to protest under the institutionality of democracy. We are protesting, of course. And what's very important right now, what's one of the biggest discussions right now is that children and youngsters are protesting in the institutions. And I don't think we should neglect that. That's a very important thing to consider. And the other thing that I would say is that how can they not be granted the right to protest in the institutions when we're talking about the future of the planet, when we're talking about a time when we won't be here, but they will? How can you not consider that? Well, these lawsuits are the basis for those considerations. These lawsuits, which are the first of their kind in my country, in this country, are, we hope, the basis for every children or every youngster to be able to do so in the future in any context, not only in climate change, but in any context. So I'll leave it at that.
Thank you. Thank you so much to all of you for all your questions. If you have any follow-ups or we didn't get to your question, please feel free to reach out to any of us. You can look us all up. We're all online and very findable, and we would be more than happy to chat with you and discuss more. And I just want to close by saying that it is, I believe, unfortunate that anyone would have to sue another entity, much less children having to sue our government to protect our natural resources. But I am incredibly proud of my brave co-plaintiffs here in Florida, as well as the children all over the world involved in their respective cases. There is no more important issue to our generation, much less future generations, than the health and the safety of our environment, starting with our climate change crisis. Our concerns related to the global climate change crisis grow by the day. And while broad in their impact to the health and well-being of people, economies, and our environment, it is critical that our societies significantly evolve in sustainable ways. The children and I are humbly placing our concerns into the hands of our legal system in hopes that the judges will have the wisdom to remove politics and special interests from the discussion, to focus on the overwhelming facts that support that human use of carbon-emitting products such as fossil fuels is causing our climate to warm, and that they will hopefully take action. The time has come for our political leaders to step up and to lead the world into a sustainable future, to close the chapter on our fossil fuel history, and to embrace factual-based science. Whether COVID-19, raging wildfires, increasingly more frequent and larger catastrophic hurricanes, and other exacerbated impacts that we have been experiencing, they should all make it clear to all of us that we must do better. Although the executive and the legislative branches of our government have failed the youth generations, the good news is that the judicial branch has the law on our side. As stewards of our states and our countries, we have the moral obligation to solve this problem. And it's my hope that our legal systems will help us draw a line in the sand and the snow to stop the damage and to begin implementing solutions while Florida's beaches still have sand and Alaska and Canada still have snow left, before it's too late. Thank you again to all of our panelists for being here with us today, and thank you to all of you for joining us.